Welcome, and on this episode of the C.Arb Kenya podcast, we have with us a dispute resolution lawyer of over 3 decades. Yes, you got that right. That is a whole lot of experience, and within that experience, he has been named or described by the Chambers and Partners Global Guide 2025 as a creative, a practical solutions-oriented lawyer. And he thinks out of the box. Yes. And even with the ability to think out of the box, he was appointed and has served as the chairman of the Kenya Sports Disputes Tribunal. That brings us to our conversation today with regard to sports disputes and sports law and sports arbitration. We're going to hear a lot of that. We have with us none other than most celebrated, long description and CV, Mr. John Ohaga, Senior Counsel, Chartered Arbitrator. Welcome to the podcast.
Thank you, Akoth. Thank you for that very flattering introduction. I'm really glad to be here. As I was telling you before we started, this has been some time in the making.
This has been the most relevant time to have this conversation.
Actually, yeah, you're right. So it is, I suppose the time is always right. Events have conspired to ensure that we can discuss this at the right time.
And you have been serving on the task force because you were appointed about a year ago. And
yes, in November of 2024, that's when the task force was first appointed. We had an initial 6-month tenure, which lapsed before we could finish. Then there was a break, and then our term was extended. And we've had a few logistical difficulties, but finally we've been able to complete our task. And I have to say that I am very pleased and proud of the output, which I hope will benefit Kenya.
You know, we've just jumped straight into it. There's some who might not know what this task force is we are talking about. Yes. So what is this?
Well, the task force, this was a task force appointed by the Minister for Youth Affairs, Creative Economy and Sports. My focus is on the sports part. And he appointed us task force whose mandate was to review the institutional, policy, and legislative framework for sports in Kenya.
And I'm glad that it was very specific, sports.
Yes, I am.
Because that takes us back to even your history. Let us go back to how did John Ohaga, before the tribunal, before the task force, experience sports? And perhaps did that even ever influence, you getting into law?
I don't know about getting into law, but I do know that I have always been interested in sports. I mean, as a child, I played lots of football, athletics. I grew up within, shall I say, educational institutions. My parents were both lecturers. They lectured primarily in teacher training colleges. So there was always a football field. And despite being quite young, I would join the students at the time in their training. I would try and participate with them, have fun with them. And incidentally, my mom taught physical education. So you can see where that came from. My mother went to the University of Melbourne in Australia back then when, before independence, and had a degree in physical education. So she was a very sporty lady, and I think I got that gene from her. So I played football. I was an athlete. The sprints were of interest to me. I was games captain actually at Alliance High School, where I went from Form 1 to Form 6. I was in the first team for football, for rugby. I was in the athletics team. I was in the first team for hockey. I played handball. So every conceivable sport that I could test my skills in, I tried to get involved with. When I joined the University of Nairobi, I was able to get into the university team in first year. So I played for Moon Machine, that's what it was called. Because when I got to university, I had to narrow down to the sport that most interested me. You know, at that level, you can't play everything. And so I focused on rugby. Rugby was the highest profile sport anyway at the university. And then I was selected for Kenya. So I played for Kenya as well, rugby. So I've been able to play sport at the highest level. And I've always been passionate about sports. So in many ways, I can't say that sport influenced my studying law, but through my life I've found that the two have complemented each other. And I continue to be very passionate about sports. And now that I can't play, I'm very interested in governance. I'm very interested in ensuring that sport can flourish and that we create the proper ecosystem for Kenya to be able to continue to be a top sporting nation.
So sports was always deeply ingrained in you for sure.
Sport was always deeply ingrained.
And that makes it a perfect play out and an intersection, because then from the pitch, with that experience, even if it wasn't very, very recent, but with that experience of being a sportsman, and now you bring it into the boardroom.
Yes.
But now in your practice as a lawyer, you now get sports with the intersection of law and arbitration. How is that, the comparison of on the pitch, boardroom and governance?
Well, let me just take a step back so you can understand my journey. So after I finished my playing career, the Kenya Rugby Union asked me to help with drafting a new constitution for the Kenya Rugby. And so when I embarked on that, one of the things that I included was a dispute resolution mechanism to enable rugby to be self-governing. And so I created, as it were, a first instance tribunal, which would be manned by people who have an understanding of rugby. And then I created an appellate council within the constitution. And after the constitution was passed at I forget what year, the annual general meeting, the officials of the Kenya Rugby Union came back to me and asked me whether I could chair the appeals council. And I was very happy to do that. So I had my first real test of resolving sports disputes on the back end of my rugby career. And so most disputes, whether they were on the field disputes or disputes around disciplinary sanctions, disputes around promotion and so on and so forth, within rugby would be determined at the first instance. And if there was an appeal or a dissatisfied party, they would then come to me. They would come to my appeals council, of which I was chair. We would sit as a panel of 3 and we would determine the matter. And that gave me great satisfaction because it essentially kept rugby disputes out of the courts. And rugby was one of the first sports in Kenya, therefore, to have a dispute resolution mechanism that did not require to go into court. And so fast forward to 2013, when the Sports Act is promulgated. I had paid some attention to the pathway to promulgating the Sports Act, but I was not involved in it. And when the Act came into place, I looked at it and I saw that there was a sports tribunal, but it didn't really immediately impact me that I could get involved, because I was already doing some sports arbitration quite separately from my rugby arbitration. I had already, sitting as arbitrator, sat on 2 or 3 arbitrations involving sports, involving rugby, involving hockey, and involving, I think, football. But these were mostly claims for money, following wrongful termination or alleged wrongful termination. And there was one that involved economic rights of a sports person. So I had some experience with sports arbitration. Now, one morning, coming into the office, you know how you go through the newspapers, and I saw this advertisement by the Judicial Service Commission calling for people to apply to be chair of the Sports Disputes Tribunal. And, you know, the moment I saw it, it's like I had a eureka moment. I just thought, this is tailor-made for me. Yeah. But because I am in a partnership, I had to ask the permission of my partners to apply. So I immediately called them. I said, there's this been advertised. I'd like to apply. When you have any objection? None of them had any objection. It helped that it was a part-time quasi-judicial role. So hopefully it would not detract from my primary practice. And so that's how I came to apply for that role. There were 2 or 3 other candidates. I laugh with them because they also got selected into the tribunal as members. But I always laugh with them, and I said, you know, guys, as soon as I applied, you had no chance. Because I mean, it's one of those, I guess, when you think this is tailor-made for you, you just accept it as God ordained.
Yes, and that's in my head. I'm just hearing, shoot your shot. That's what we would say. Shoot your shot.
Shoot your shot. Yes.
When the opportunity presents itself.
Absolutely.
But that's a very, very interesting transition. You know, from commercial litigation and dispute resolution, and then you have your side gig in, you know, sports arbitration, and specifically, these were almost very sport-specific dispute processes that you're a part of. How was it now being in that sports tribunal? What was it on a day-to-day, away from the formality?
No, it was not difficult at all, because as a commercial, both in the commercial dispute space, whether as a litigator or an arbitrator, I am very focused on speed, efficiency, including cost efficiency. I'm very focused on case management, and in the end, most disputes in the end revolve around a claim for a sum of money. They are really commercial. So I brought my commercial thinking up to the sports arena. Even the way that I structured our processes in the sports tribunal were really to achieve that efficiency, to bring a commercial mind to bear on it. How do we ensure that our process is speedy, is efficient, and achieves the purposes of the sporting community? So in the same way that my commercial clients would want an efficient process and result, having regard to the time cost of money, I just transformed that into the sports arena. And I found that it was not very difficult. Certainly, the one aspect that I found I thought was beneficial to me was having a sports person's mindset, because I could sympathize, I could empathize with sports people when they come to the tribunal. I could put myself in their shoes. I could sort of try and project to what they would like to achieve. And I was very clear in the tribunal. Our philosophy was that our decision making must put the sports person at the center. So whatever decisions we came to, I said to the other tribunal members, we are not here to make technical decisions. Our decisions must move the sport forward. We must look for every opportunity to develop jurisprudence that advances sporting life, the sports ecosystem, governance, ability to compete, discipline within the sports sector. So none of this, I've looked at this case, I've looked at this case, and I find so and so is right. Where is the philosophy? There had to be a philosophy. We had to speak to sports. And that's how I approached it.
Now, for you to serve as chair on the tribunal really was a creation of the Sports Act 2013, right?
Yes.
So it then establishes the tribunal, it establishes other structures, just looking at the Sports Act as it is, because later in the conversation we're talking about, the reforms that you're expecting. What is it as part of this Sports Act that you say would have been, was a success, or is a success, or that is actually working?
I think the tribunal is a good entry point for the sporting community because it introduced a dispute resolution process that took us away from the courts. I think that sports experience with the courts has been an unhappy one from a time perspective, simply from a time perspective. Sport requires a certain environment, a certain psychological makeup, and a certain physical state to achieve optimum performance. Whether you are talking about governance dispute, whether you're talking about elections, or whether you're talking about selection of sports persons, you require to determine them speedily because they affect the sports person's performance. If you're a sports official contesting your position, you impact the sports person's ability to perform because your decision making will impact that sports person eventually. That's why you're running for office. If you're selecting a sports person to compete in the Olympics, for instance, and we had many of those disputes, and the sports person is uncertain about their place in the Olympics because there's been a challenge, or somebody who's been left out of the team is challenging for his position, they're not in a settled frame of mind. Because you're uncertain about whether you're going to compete, it affects your training regime, it affects your preparedness for the games. So those need to be resolved very, very quickly. Now, this is where I brought my arbitration training into play. When the sports tribunal was first brought into being by the selection of the members, there were no rules. There were no rules such as the civil procedure rules to guide us as to how we would determine matters. And I remember reading some articles being critical of the fact that there were no rules. I remember some articles commenting on the Sports Act and the Sports Tribunal, talking about its limited jurisdiction, because it did have a very limited jurisdiction. But they didn't worry me, because I knew that central to your training as an arbitrator is the whole concept of due process, equality of arms, opportunity to be heard, getting to a decision that is enforceable, a decision that will stand up to scrutiny. So all those became pillars for me. And I said to my members, we don't actually need the rules, even though I can assure you within a week of my appointment, I had formulated the rules, because under the Act, the chairperson of the tribunal is required to formulate the rules in consultation with the Chief Justice. I borrowed from Australia, New Zealand, South Africa, the UK. I borrowed the pathways that are known to have sports dispute resolution forums. I had looked at CAS. But the bureaucratic process of getting the rules actually gazetted took, I can tell you, even at the end of my first term, my first 5-year term, we had not gazetted the rules. So our entire first 5-year term, we operated without rules. Yeah.
That were in draft.
That were in draft. We published draft rules because we had to publish them for public participation, but they were not gazetted, they were not enforceable rules. But that never detracted from our ability to continue to sit, to be effective, and to function. Because, as I said, my arbitration training kicked in and enabled me to guide the tribunal, to guide the process, and to ensure that that we were giving everybody the fairest opportunity to be heard. And then there were other structures that the Act brought in, Sports Kenya, which dealt with infrastructure, the Kenya Academy of Sports, which dealt with athlete pathways and athlete development. And then there was the Sports Fund, which dealt with the whole question of funding sports. And then there was the Office of the Sports Registrar, which dealt with registration, licensing, and recognition of sporting organizations. And I thought those were really good in terms of a framework for the development of sports. They began to get us organized as a sporting nation, but they had their deficiencies, and I think hence the formulation of the task force to review the Sports Act.
What are some of those deficiencies in your view?
Well, first and foremost, these merely set out structures. I always think that legislation must be underpinned by some policy. What are we trying to achieve, right? The Sports Act of 2013 was a legislation that began to be formulated prior to the 2010 Constitution, so it needed to be aligned, right? There was no consideration of the role of counties in sports, and yet the Constitution makes sports a devolved function. The other thing was that it was predicated quite a lot on our sports policy of 2005. So the two were not sitting in sync. And then it set up these institutions, which initially were theoretical. We had to see how they would function. And yes, they have to a certain extent served us well. But especially with the Sports Tribunal, there were limitations because its jurisdiction was very limited. And we had to continually craft decisions to expand our jurisdiction. There were constant challenges to jurisdiction because, respondents are always trying to either delay, detract, or find ways in which they're not brought to account for their actions. And yet plaintiffs want remedy.
Progress.
Right? They want progress. And we had to find a balance. So when, for instance, we had to decide between the rights of a player in relation to the termination of his or her employment, and the question whether that belonged to the tribunal or that belonged to the employment court, we had to now refer to sport-specific rules and legislation and to borrow from global bodies like International Olympic Committee, FIFA, and so on, to ground our jurisdiction and therefore expand our jurisprudence. So in some cases we said, yeah, we accept we don't have jurisdiction. But in other cases, we would look at the subject matter. And I was always kind to see what can we do with this dispute in terms of advancing jurisprudence from a sporting perspective in order to shape our sporting environment. And it allows you to start to think about how judges and superior courts think, because you look at disputes and you look at those disputes as the same way you shape a clay pot, the same way you have plasticine, it's malleable. How do we use this dispute to shape our sporting arena, so to speak? And so that's what we set out to do.
But even as we look at what were, the weaknesses perhaps of it, I remember, because by the time the task force was being pushed together, there was some uproar, and most of this uproar is what we'd say pale kwa ground. Those who are, now using the sports policies tangibly.
Yes.
So for them, it would be, we don't have a policy problem. In fact, on paper, I think we are progressing well. It's an execution problem. So how does then that transition between the Sports Act as we have it now and what we're seeing as drafted by the task force trying to achieve in terms of the execution element?
Somebody has to execute. And the person who is called to execute must have a vision. Yeah? Because for me, in order to run sports effectively, actually in order to run any organization effectively, I think you must have a vision. And I think you must start with that vision in order to then formulate your pathway, because your pathway becomes the milestones that you are executing in order to achieve that pathway. Yeah? And so that must bring you back to a policy. You can't execute without a policy. Remember, you're not doing it for yourself. Yeah? You're not, when you are a steward, it isn't for yourself. It is always for somebody else, for generations to come. When you're a decision maker, if you're the cabinet secretary responsible for sports, you're not the one going to be sprinting, but the policies that you formulate, what you're executing will allow that sprinter, that rugby player, that footballer, that swimmer to be able to focus on what it is they're doing and execute. So there is execution at different levels, and you must understand those levels and the hierarchy of those levels. So I disagree with people who say that we don't have a policy problem, the problem is execution. One necessarily feeds into the other. If the policy is defective or deficient, then the execution will be deficient, because the policy sets out your vision, and if the vision is either short, or the vision doesn't capture or carry everybody, or the vision doesn't properly articulate what is sought to be achieved, then you cannot properly execute. So I think the way that I think about it is that in many ways, Kenya's sporting prowess has been achieved notwithstanding our failures in execution, right? So we have raw talent that we have sent out onto the global stage in a lot of sports, and they have achieved global success despite the shortcomings that they have faced. If those shortcomings were fixed, imagine how the other sports would be able to also perform. Because there are a lot of sports which depend more on structure than just raw talent. If you're putting a team together, the team must be coherent. Yeah? So how do we ensure that we carry along both individual sports and team sports? And this is where I think coherence, this is where structure, policy, and legislation comes in. And then we must take account of modern day realities, the impact of technology, the impact of science, sports science, research, nutrition. These are some of the things we're now talking about through the sports policy that we're formulating. How do those impact our ability to compete? Because more and more now, sport is becoming very scientific, very technologically driven. The game is much faster now, it's more watchable, because again with sports, you have to take account of the spectator. Who wants to play in an empty stadium? In fact, some of the sanctions that are imposed on sporting teams include playing in an empty stadium, because they know that taking away your fans or taking away the spectator element is a sanction. But we play sport to entertain. We play sport for our fan base, yeah? And we must recognize the fans. And that's one of the other things that we've taken account of in the new policy, the recognition of fans, yeah? And creating a forum for fans associations to organize themselves, to feel that they are acknowledged and that they are recognized. because we think that they're so central to the promotion of sports. Yeah, so there are a lot of those things that we have tried to think through, and that were not previously either in the Sports Policy of 2005 or the Sports Act of 2013.
Yes, because I can only imagine if you are going to be part of a task force, and within the task force, then there are also diverse backgrounds,
yes,
different stakeholders and players who are a part of this task force.
Yes.
And because we're shortly going to come into the dispute resolution processes, I can only imagine that when all these members of the task force are coming with their experiences of what a proper roadmap needs to look like, what a proper policy needs to look like, there must be some tussle at some point or not. So how do you come to a draft that is a coherent and cohesive draft that represents all these people and all these influences?
Yes, certainly there has to be tussle. There has to be friction. I always think friction is good, providing that you direct your energy properly towards trying to appreciate where that friction is coming from, why, and how we can use it to propel ourselves forward. Friction can also be negative. So within the task force, there are many areas we had to negotiate. There were areas that some members of the task force did not understand why other members are interested in a particular area. And that's because everybody comes with their thinking, with their background, with their philosophy, and with their constituency, incidentally. It's very interesting that everybody has a constituency. So if you have come from an athletics background, that's how your thinking is modeled. And it may be more difficult for you to understand the thinking of somebody who comes from a background that relates to a team sport, for instance. Yeah? Why are you interested in this? These are things we had to argue back and forth about. You have to approach each engagement with an open mind, understand where that person is coming from, articulate your position, negotiate it. Of course, my role as chairman was to moderate. And I think that this is why, when I think back now, chairing a task force of that nature is not a technical responsibility. You must have the awareness of what everybody is saying, the ability to listen, to moderate, to take it in, to shape it. Because one of the other things I found was that you might come with your ideas, but they're not fully formed. They're not fully articulated. So I need to be able to help you as a member of the task force to actually articulate your ideas properly and bring them out. Yeah? Because otherwise other members of the task force might think that you're not really contributing.
And I think what you're saying is almost my next question.
Yes.
I was about to say, let's bring it closer home. Because when you have a background of mediation, a background of arbitration, and general legal dispute resolution, and you find yourself in that kind of space, how is your brain thinking? How does your ADR skills come into play in that environment?
Oh, that's actually, yeah, I'm glad you asked that. Actually, I found that came into play a lot. I don't think the minister had taken account of my ADR skills when he appointed me, but certainly I've been involved in ADR. And just stepping back, I chaired the task force for the formulation of the ADR policy in Kenya.
Yes.
So obviously I had that skill set at the back of my mind. I actually leaned very heavily on the deliberations we had at that time.
So for someone who is unfamiliar with sports dispute processes, could you walk us through the beginning of it to how it plays out?
Well, with sports disputes, you have to understand that you can have the most mundane dispute to the most complex dispute. And there is no one size fits all. you must try and pigeonhole each dispute and try and resolve it within its context. That's what I would say. So when we started at the Sports Tribunal, I tried to anticipate each nature of dispute. Some would take us by surprise. So for instance, if you receive just a letter, and sometimes the tribunal registry would call me and say, we have received a letter, but how hawajaandika plaint ama statement of claim, tutafanya nini? I would say fungua file. Yeah? Then we would look at it and discern this individual, what is the nature of their dispute? And who is the protagonist? Who is the other party that should respond? Because sometimes the dispute as presented may not necessarily be sophisticated so as to identify who the respondent is. And you would have to identify who is the respondent. Sometimes it would be multiple respondents. Sometimes it would be the Ministry of Sports. Sometimes it would be a federation. Sometimes it would be all. And we will then have to say to each of these, we have received this letter. We think that this particular issue requires your response, and we think that this one requires somebody else's response. And we're setting this matter down for mention on this date. Please show up. Other disputes would be articulated by lawyers who, of course, have the sophistication to be able to present it in the way that it should be presented. But sometimes it would be overly complicated. So it's very difficult for me to tell you that these are the stages, yeah, because in the tribunal that has not been my experience. My experience has been that I have had to take off my sophisticated commercial arbitration or litigator's hat and put on the hat of the dispute resolver who tries to accommodate every nature of dispute that comes before you, identify who should respond, and then identify how you should deal with it. And this is therefore more sort of homegrown, in the sense it had to be fit for purpose, fit for our people, fit for this jurisdiction. It couldn't be, we couldn't say that we must align it with the way CAS, for instance, recognizes disputes, the way CAS appoints its arbitrators, the way CAS's procedure is set out. It had to be something that was progressive, and that's what it has been. Now there are rules. Yeah, the Sports Dispute Tribunal rules are formulated. The rules set out what needs to be done, how your statement of claim should be formulated, period of response by the other party, joinder of parties, amendments, all those things, written submissions, etc., etc. So I would say that each dispute that came before us, we shaped it as we thought we needed to and gave it life as we needed to. Where there were jurisdictional challenges, we resolved them, sometimes with the end in mind, I have to admit.
Yeah.
And it has been a process of evolution, actually. And I think that this evolution will then inform the next iteration of the rules, because rules cannot be static, they must be responsive. I expect that as we go along, that there will be rules that inform how new disputes are dealt with. The other thing that I have to say is, which we had not anticipated, and I myself had to go back and do a significant amount of research. There were emerging sports which are not non-traditional sports. You know, esports, for instance, how do you resolve disputes around esports? And we had disputes that revolved around some of these emerging sports. I mean, it informed, now back to the policy, it informed our decision to ensure that we accommodated emerging sports within the policy and the proposed legislation. And same with dispute resolution, therefore.
Yes.
Yeah?
Yes.
Same with dispute resolution. You must allow that space. We had sports that I had never heard of come to the sports tribunal. And then I had to go and look up the sport, teach myself. Because when we started with what we might call traditional sports. We used to say, are they Olympic or non-Olympic? You know,
that was how you categorize.
That was how we categorized them. Now there are sports that are not Olympic sports. They have no forum globally at which there is competition, and yet somebody is creating a forum for them to compete, and obviously spreading the gospel of that sport globally, coming to Kenya, going to Tanzania. And then we had sports in which we found that even within one sport, different factions of that sport, there were sports people who participated in both. Yeah. So how do we accommodate this sport in order to enable this sports person to fully express themselves in this sport and that sport? So you really have to keep an open mind about this. You cannot be closed-minded about it.
Any examples of this emerging sport? Because I can imagine from those who are listening in or watching, they'll be asking, what is that Mr. Ohaga had to research? I would ask myself, are those gamers on their laptops or computers categorized as sportsmen in that way?
Actually, we have had to expand the definition of sports in the new policy and proposed legislation. Because there are sports, it is competitive, it mirrors a sport, yeah? So sport is no longer just about, and this was actually something we had a lot of friction about within the task force. The question whether are these sports, yeah? Is sports only a physical activity? Because sometimes we think about sports as just a physical activity. But there's sports for competition, there's sports for recreation, you know, and it had to be all inclusive. There's sport for people who just want some exercise. How do we also include them? And then there is sports, people who are just armchair gamers.
And mental sports.
And mental sport, chess.
Yes.
Yeah. Chess is a mental sport. And yet it is recognized as a sport. So that was our starting point. If you recognize chess as a sport, if you recognize a jua
as a sport, yes.
Yeah, then why wouldn't you recognize gaming? Why wouldn't you recognize esports?
But now look at how sports is growing. Like you said, it's no longer static, and we have to evolve.
Yes.
Even in terms of our definition. And our law itself has evolved to the point that even the Constitution recognizes alternative dispute resolution. So then how do we extrapolate that which is the Constitution into this area of sports? I would ask, what kind of sports would you say you'd leave for ADR, like mediation and arbitration? And then what are those that perhaps in terms of their characteristics or the characteristic of the dispute you might want to leave to the courts?
Can I be honest with you?
Yes.
I would not leave sports to the courts.
At all?
At all. I would not leave sports to the courts at all, because the court system, in my view, is simply not designed to serve sport. The courts are designed to serve a specific purpose. Dispute within particular, what shall I say, what's the word I'm looking for? I mean, if you're looking at constitutional interpretation or the interpretation of a statute, you're looking at enforcing a commercial bargain, you're looking at those areas that lend themselves to resolution through the court system. You can pigeonhole them and categorize them. But it comes back to why the philosophy behind the formation of tribunals. Yeah? I think the Constitution itself recognizes that not every dispute or not every area of our lives, not every human endeavor is amenable to resolution through the courts.
Yes.
Hence, specialized tribunals.
Yeah.
And just to sidetrack, when I was at the sports tribunal in the first 5 years, I think, we began talking about a tribunals bill, which would have a structure where disputes or appeals from tribunals would then have a specialized body for resolution of those disputes within a time-bound structure, and we'd have a provision where only questions of law would then go on to the High Court, and perhaps appeals would end there. And this was a recognition that the tribunal structure, because it is specialized and serves specific areas of our lives, is intended to bring a specialized thinking and resolution by people who are aware of the nuances. Yeah? We cannot ascribe to judges knowledge of every area. Yeah? And that's why the Constitution, in fact, the framers of the Constitution eventually agreed that there needed to be a specialized court for environment and land, specialized court for employment and labor relations. They didn't create a specialized court for constitutional matters, but there are divisions. Yeah? There's divisions relating to criminal matters, there's divisions relating to anti-corruption and economic crimes, commercial matters. And so we recognize that there are those divisions. And for me, sport is one of those areas that should be kept out of court, unless you want to litigate issues that are so fundamental to human rights, because now it goes beyond just sport. But having said that, I think you still need to have a sporting mind frame. Yeah? And you need to take expert opinions around areas of those in order to craft a decision that moves the sport forward. So if I could, I would totally keep sports out of the courts. I know that there are many times that people take sporting disputes to the court. A lot of it is for strategic purposes, because people exploit the bottlenecks and speed of the court system. And we have to be alive to that. And a lot of those are strategic, not because they think that they will get a better decision from court, but because it will suit something strategic. But there's nothing you can do about it. You know, as chair of the tribunal, I can't go to court and say, Judge, send this to the tribunal. The judge needs to be astute enough to say, there is a specialized tribunal, you go there, and let that tribunal determine this matter. Sometimes courts rely too much on the parties to bring to their attention the existence of other avenues. I think that courts themselves need to redirect disputes.
Suo
motu. In the same way that now in the commercial division, judges see an arbitration clause, they will straight away direct you to arbitration. If I remember, the late Justice Havelock, for instance, had that philosophy.
Yeah.
People like Justice Jackie Kamau, who had an arbitration background, would not wait for an application to take the matter to arbitration. They would recognize the arbitration clause in the contract and say, have you activated this? This is where we should be. And I think that courts really need to do that with every nature of dispute.
So if we not yet have those specialized sport courts, but we do have the tribunal, but as an individual or as an organization, I realize there are alternative dispute resolution processes. What nature or at what point of a dispute might I want to think about mediation or arbitration, or going directly to sports arbitration?
I think it depends on the nature of the dispute. There are some disputes that are not amenable to mediation. For instance, one of the provisions under the Sports Act gave the tribunal jurisdiction to deal with selection disputes. If I am competing to be selected to a national team, there is a threshold that I'm required to meet. So for instance, if it is an individual sport, and it says for 100 meters, in order to get into the next stage, or into the national team, I must run 10.7 seconds at least. That's not amenable to mediation. Either I make it or I don't. But there are other disputes that are amenable to mediation. Termination disputes, for instance, termination of the sports person. The sports person is seeking compensation because of the nature of termination, or the sports person is seeking some sort of clearance in order to free them to go and compete for another team. This can be resolved, should be resolved. It's about negotiation. Disputes where minor disciplinary infractions, I think, can be mediated. Major disciplinary infractions, perhaps not, because then that might go to sporting integrity, and you don't want to impair sporting integrity by mediating the outcome of a significant breach of discipline. Remember, sport is also about discipline. As a sports person, in order to attain the highest level of performance, you must be disciplined. So you should not be seen to be impairing that. And so I think that it depends on the level of infraction. And I mediated numerous disputes as chair of the sports tribunal, incidentally. Sometimes it appears counterintuitive that I should not sit as chair and then take on the role of a mediator. But there are instances where we would appoint an independent mediator. I found that we had limited success with that because it's an interesting thing, but parties also respond to the level of authority that they see that the third party neutral is bringing to the dispute. That was my experience. And I found that as chair of the sports tribunal, when I was sitting as mediator, I still brought the authority of my office as chair. And the parties, therefore, were better engaged in seeking to find a resolution. And we actually successfully mediated many of those. I mean, if I started to tell you about them, we would be here until midnight.
At the end of the day, the goal is to reach the ends of justice.
Absolutely.
So in my view, if that was able to achieve that, and the parties were able to accept that, then it works.
Absolutely.
For us, our generation would say a win is a win.
A win is a win.
A win is a win. Ideally, that is what really ADR also stands for. By the time we are going into this process, it needs to be enforceable, it needs to give us some element of finality to the dispute.
Absolutely.
Interesting that you mentioned the integrity element. Because then I ask myself, looking at the draft bill, it introduces the National Sports Integrity Unit, right? So what is that really meant to do? And I'm comparing it when we look at, for example, arbitration, where we say there are certain matters of public policy that cannot be submitted to arbitration, for example, elements of corruption. So what really is this draft bill targeting with this introduction?
Well, sporting integrity is a very specialized term within sports because the whole intent of sport and competition is to play clean, win clean. And that doesn't stop just at anti-doping, for instance. Match fixing, absolutely. And match fixing has its many facets. Match fixing can relate to a goalkeeper letting in easy goals. Yeah, it can relate to a referee making suspicious calls or favoring one team or the other. Yeah, but it goes beyond that. There are people outside the playing field who are manipulating the outcome for financial gain. That goes to sporting integrity. Yeah? Sporting integrity, even in relation to fans, hooliganism affects sporting integrity. Yeah? Sporting integrity, my goodness, it is so wide. Only this morning I woke up to the news of this Real Madrid player, Vinicius Jr., being subjected again to racist chants, racist abuse by another player from the opposite team. That is sporting integrity. Because sports people, even when you're in competition with each other, need to treat each other with respect. This is one of the things that I have to say rugby really taught me. On the playing field, I can tell you, rugby is brutal. You know, you're tackling the other player, physically tackling it. You know, football, the tackles, people break their legs and so on and so forth. But sometimes I see footballers rolling all over the field and say, come on, what's that about? In rugby, you are fit.
Tackle.
And rugby players train to tackle.
Yes.
Yeah? Punch-ups flare up in rugby. Yeah. In fact, I used to be amused because sometimes the punch-ups, the referee would stand aside for a while and let you
finish.
Yeah? But let me tell you, at the end of the game, everything is left on the rugby field. The teams clap each other out. And maybe we no longer do this. Today, in today's environment, but they end up at the bar, you share a drink, and later you sing and laugh and chat like...
I think they still do.
Maybe they still do. And that, for me, that philosophy from rugby I've always carried with me. Sport, my goodness, it is so wide. The use of technology, now we're talking about esports. You know, you can manipulate that technology now because technology is amenable to manipulation. That is sporting integrity. So, sporting integrity requires a multidisciplinary approach. And we had a lot of friction, incidentally, about this at the task force. Some schools of thought said, oh, but you know, there is DCI. You can always report to DCI. Or there is anti-corruption. And the view I had was, those agencies are not suitably trained to deal with sporting integrity. You know? Sporting integrity requires a multidisciplinary approach. You need somebody who is well-versed in technology. You need somebody who is well-versed in investigation. You need somebody who is well-versed, doctors who are versed in substance abuse. And not just doctors, even people trained in nutrition and so on and so forth. You need, thinking about the incident I just told you about, even people versed in lip reading. Yeah? Because what did that player say to the other? In order for this player to become so enraged. Yeah, and you know, if you watch TV these days, every player sort of covers their mouth when they're speaking because they don't want their lips read.
Yes.
Yeah? Sometimes it may be tactics that you're communicating to your teammate, but sometimes it could be something more insidious. So it requires a real multidisciplinary approach. And if you look at the definition of competition manipulation under the proposed new bill, you will see that it is very wide. And then if you look at the provision relating to sporting integrity, you will see that we have tried to be as as broad as possible. If there is no sporting integrity, it also affects the commercialization of sports. Because we want to stop talking about sponsors for sports. We want to talk about investors. Because sponsorship has the connotation of something ex gratia.
Support.
Yeah, I'm giving you support, I'm giving you help. Sport doesn't need help. Sport is a multi-billion
It's an industry. Yes.
Yeah, globally. And Kenya needs to wake up and realize this. It is a multi-billion dollar industry. We need to stop looking for sponsors. We need to start looking for investors. Come and invest in my team. Come and invest in me. Come and invest in my sport. Come and invest in infrastructure. But investment presupposes a return. Yeah? Sporting integrity, in the end, connotes the recognition that there can be corruption in its different facets in sport. So what does sporting integrity seek to do is to stamp out that corruption so that sport can be attractive both to players participating, to investors, to fans, all the stakeholders. Yeah? Even in terms of funding sport, some of the stories we had about the misrepresentations made to the Ministry of Sports by some federations seeking funding impact sport integrity, because they misrepresent what they're going to do with the funds, who they're going to support, and the entire utilization of those funds. That is sporting integrity. But it doesn't just connote policing, because policing has the connotation of essentially looking out for wrongdoing. What we also sought to do was to introduce education, educating sports people, educating fans, educating investors, educating sports stakeholders as to the importance of integrity in sport. And this is the same for, you talked about public policy in arbitration. This is the sort of same education that we need to have as arbitrators, as to the importance of keeping our environment corruption-free, making sure that your awards can stand up to scrutiny, because the formulation of them has been a process that stands up to an integrity check. So that is I often think about, and sometimes I say to my pupils, that even the cases that I handle, I think about them as a sport.
Yes.
And me as either if I'm counsel as a competitor in the sport, but if I'm an arbitrator or presiding over a decision-making process as a referee, and you want it played clean. So how do you ensure that you're part of that process?
At the end of the day, it comes back to you and your reputation, which is a very important thing.
Absolutely.
And I'm glad that this conversation has transitioned into the commercial side, because then now we're talking about investors. By every means possible, we're about to talk about contracts and agreements, right? So how does the draft Sports Bill 2026 then address elements or approach elements like arbitration clauses or dispute strategy planning? For the players, for example, if I'm going to get into a contract, or sponsorship deals, just like we were saying, or any other commercial arrangement, how has the bill anticipated this kind of arrangement?
Thank you for asking that. One of the things we've provided for in the bill is that sports organizations, we call them federations, must provide sports people with adequate legal representation when they're entering into contracts. Hopefully, we will have enough lawyers trained in sports law to be able to assist these players to formulate clauses that are beneficial to them, that do not introduce an imbalance in bargaining power. That's the way we have approached it. We thought that if you embed within statute a requirement that the sports person must have access to legal representation, number one, it also deepens the opportunities for sports lawyers, encourages more and more people to take up sports law. And for me, this comes from the fact that when I was chair of the tribunal, one of the things we encouraged was to have a pro bono list of lawyers serving the tribunal, so that when parties came before us who were unrepresented, we could assign a lawyer to them. Because my experience was that a lot of people had legitimate claims or even defenses, but they didn't quite know how to articulate them. And so assigning lawyers to them was a way to correct that imbalance within the tribunal. And I was very encouraged by the number of people who listed. In fact, that list continues to grow at the tribunal. And people used to call and say, Chairman, I haven't been assigned anything. Yeah, and they ask you to do pro bono work. And, it has sparked an interest in sports law. One of my pupils, who previously had no interest in sports law when she came into the firm, went off to do her master's in sports law. I received numerous requests from lawyers wanting references to do their master's in sports law. Only today, I received an invitation from Royal University to speak at a sports law conference. So sports law is gaining prominence, but we must also find work for these sports lawyers. So by giving access through legislation to legal representation, not only do you create work for a growing army of sports lawyers, but you also ensure that sports people have proper representation. But not just that, even clubs, sports organizations, sports federations require proper legal representation to know what sort of clauses they should be putting in to their contracts. I'll just give you a very simple example. In fact, I was reading this. I read a lot of material around sports law. And I was reading this, without naming players, the EPL, the English Premier League, is the richest league in the world. Of course, there's La Liga as well. And they were contrasting a case of one footballer whose club inserted what is called a sell-on clause, in which they said, if you sell this player onto another team, you pay us 10% of what you get. And another club which did not insert a sell-on clause. Yeah? Now imagine these two starting off as young players, both become very good. And they both attract £100 million bids. One club that inserted a sell-on clause reaps the reward from that sell-on. The other club just watches on, because they didn't have a lawyer astute enough to insert those clauses. So it isn't just sports people who require proper legal representation. Everybody requires proper legal representation within the sports ecosystem. And so we need to have more and more sophisticated contracts around sports. But not just in relation to sports people, even in relation to infrastructure, like stadia. What you put into those contracts is very important. What can the stadium be used for? Is it just used for sporting endeavors? Is it available for use for other things? Rights of access for people with disability, ticketing, readiness for digital media. All these contracts which relate to infrastructure, all of which require sophisticated legal arrangements. So the lawyer is actually going to be so integral to the realization of the objectives of the sports policy and the sports bill of 2026.
That takes me to the next question, which is two-faceted. So I have a section of lawyers who will say there's no such thing as sports law. It's just sports and the law, and you figure out how the two get together, right? So the question is, as a lawyer, do I specifically need to be trained in what we call quote-unquote sports law, or I just have to find out how my experience and expertise in law will fit in the world of sports somehow? How do you make it happen?
No, that's naive.
How do you make it happen?
That's naive to think that you do not require specific sports law training. You do. Sports law is a very specific species of law. Yeah? Sports jurisprudence, like sportiva, we call it, is very specific. I don't have specific qualification in sports law. What I have done is to educate myself, read decisions of the Court of Arbitration for Sports, read numerous articles. I've attended numerous sports law courses, so I've got numerous certificates in sports law. But for instance, just to be a FIFA agent, FIFA has a specific course that you must attend. Why is that? Because you require a specific skill set in order to represent footballers. IOC, the International Olympic Committee, athletics, AU, has specific requirements for training if you're going to represent an athlete. The same with a lot of these global federations. Why do universities frame specific curricula for sports law? Yeah? It is because of the recognition that it is such a specific area of law that you cannot just say that I am a lawyer and this is sport and I will bring them together and I find my way around it. No.
There has to be training.
There has to be training. And more lawyers need to take up sports law, training in sports law, if they're going to be able to effectively represent sports people. Let me tell you another area. Under the Sports Act, we have jurisdiction to deal with sports-related disputes. And then the Anti-Doping Act came into being in 2016, I think. And that also gave the Sports Tribunal jurisdiction. I have to confess it was a steep learning curve because anti-doping has its own peculiar jurisprudence. You cannot just say I'm a lawyer and I can represent somebody who is charged with an anti-doping rule violation. It is very complex. That's all I would say now. It is very complex. And you need to equip yourself. And in fact, it was because of the whole anti-doping environment that we actually first set up the pro bono list, because we had many young athletes coming charged with anti-doping rule violations who knew nothing about what they've been charged with, how to defend themselves, what the violation involved, the nature of the substance that they had ingested, how it was categorized. I mean, it is so complex. What the potential sanctions were, how you can mitigate those sanctions, what your the defenses available to you are. I don't think that you can come into an anti-doping law environment and throw in Article 50 because anti-doping has completely reversed the burden of proof. Yeah. It has reversed the burden of proof. So there is no such thing of you're innocent until proven guilty. Actually, you're guilty until you prove yourself innocent.
Yeah, which is also very interesting because then, yes, as a lawyer, fine, I have to get my training in sports law. At what point do I say sports arbitration is where it's at? Do I again need to get into some different kind of training for that? And as we talk about even sports arbitration, then we also in arbitration talk about by the time I'm entering into a commercial agreement, I want specific players or specialized players, right? So if I'm getting to a contract, I want my lawyer there. I probably want the property valuer there. I probably want, the surveyor there, so that all these technical elements are taken care of at the point of getting to the agreement. In sports as well, when you start talking about sports law, is it important to bring in these other players at the point of drafting, or we're just talking about I have a specialized lawyer and that's enough?
No, it's no longer enough, actually. Let's move away from the sports person now. Let's talk about sports infrastructure. You build a new stadium.
Yes.
Yeah. You need somebody with expertise in environmental management. We're talking now more and more about green spaces. Yeah. We're talking about more and more now about community engagement. You engage because stadia takes up a large proportion of any area where you're building it. You need traffic management. Yeah. You need to talk about security, planners. Yeah. You need to talk about outside of just sport. That facility, is it amenable for use for other activities? For instance, Talanta now, in addition to just the seats, you'd imagine that a stadium will just have seats for spectators. There are boardrooms in there. Yeah? You require boardrooms because you want to be able to say that I, John Ohaga, would like to invite my clients to a sporting activity. Yeah? But if my clients are going to come there for a sporting activity, perhaps we can arrive 3 hours early, and we can have our meeting there. We can have our board meeting there. Make use of the conference facilities there. You have to talk about catering. Yeah? All of these are specialized. So just saying that all you need is your lawyer and the developer, or your lawyer and the sports person, does not give you a 360-degree view. And it's getting more and more complicated. Technology now has come into the equation. How do you deal with technology? My goodness, there's just so much.
It's vast.
It is vast.
Yeah.
But it is no longer just the lawyer and the sports person writing contracts. It is thinking about, even with a sports person, thinking about the sports person's entire existence as a sports person. When they wake up in the morning, what pressures are they subjected to? Many teams now require sports psychologists.
Yes.
They require sports psychologists to enable you to achieve optimum performance. Mental health is a big part of sports today. Are you going to write that into the contract for the sports person, for instance? The players' image rights, can you project them? How are you going to cost them? When the sports person is negotiating with a potential investor, what are you going to be asking for? How do you reach those numbers? So you also require somebody versed in financial formulating financial projections and being able to say this is the value of this individual and it will grow, and be able to justify how it will grow and why he's such a priced individual. And then you have to think about the playing environment. You think about you and me running, playing football, but think about equestrian sports, for instance. It's a sports person on a horse.
Yes.
Or think about polo, a sports person on a horse,
Yeah.
That horse also has some rights. It is owned by somebody, not necessarily by the person riding the horse. So you have to think about those things. So, and unless you're alive to those nuances, and you just come in as a lawyer who has experience in doing charges and conveyancing documents,
It will not work.
It will not work.
It will not work.
It will not work.
Oh, yeah.
Yeah.
That really makes sense. So, assuming the new framework that we're anticipating with the draft sports bill and the national sports policy as well come into play, what is it that perhaps you think would be immediately affected that reflects how CAS plays out?
I wouldn't say immediately, because from our perspective, CAS is an appellate structure.
Oh, yes.
Yeah. So, which means that from a dispute resolution perspective, you have to commence the dispute with the primary dispute processes that we have put in place. And then, if parties are dissatisfied, then find your pathway to CAS. So CAS doesn't come into play immediately, but you have to be alive to it. You have to be alive to the existence of CAS, and that you might eventually end up there. But you have to bring into consideration costs and so on, the cost of access, the nature of your dispute, the fact that CAS is not like the High Court. You know, CAS is just a group of, it's a secretariat, but it's independent arbitrators selected to sit and determine different sports disputes. Yeah. So you must also then write CAS into your constitutions or into your contracts to give CAS jurisdiction. Yeah. So because it is that jurisdiction, CAS, in the end, like any other arbitral institution, must respect party autonomy. Yeah. So I can't just howl you before CAS because you and I are in dispute. Did we agree? So most global sporting federations will require that disputes relating to a category of affiliated sports persons be resolved through CAS. So they will set up primary mechanisms with CAS as an appellate structure. But in the end, when you think about CAS, don't think about it as the Supreme Court, because the Supreme Court is a fixed number of judges. You know what the quorum will be, who the judges will be, and so on. Jurisdiction and so on. CAS is just brings all these arbitrators who have experience in sports together and selects from them.
So given that we are looking at international and cross-border some form of relations commercially, and even investments coming in, how would then, as a Kenyan jurisdiction, do we secure the interests of such investors who would want to come and be a part of the Kenyan sports ecosystem?
Investors are very interested in knowing how the disputes will be resolved if they run into dispute. So first and foremost, the dispute resolution mechanism must be one that they believe has integrity and whose decisions will be enforceable. But even before you go into that, as an investor, your first line of thought doesn't need to be dispute resolution. It needs to be, am I coming into an environment where I can invest and get a proper return on my money? So, do we have an environment that is investor friendly? That's first and foremost what we have to think about. And then that will attract the investor. Then the investor can begin to think about, if I should run into a dispute, how will it get resolved? Is there a structure that lends itself to this? And so actually we have provided for the resolution of commercial disputes at the tribunal as well. Primarily because we think that they would be resolved faster there, and so give you a fast track to resolution of disputes, and then they could be enforceable through the courts in the same way that an arbitral award can be taken for enforcement through the court process. So hopefully that inspires confidence through that that system, but also the people that you put in the tribunal to resolve those disputes must be well qualified. They must have the skill set to resolve those, to understand those disputes, understand the expectations of investors, and be able to eventually come through with decisions that can be fully respected, and that can also be precedent, because as you know, even with arbitration, potential investors look at the decisions that have been made by Kenyan courts, in terms of enforcing arbitral awards, in order to understand the jurisprudence, in order to understand what Kenya's philosophy is around arbitration. They will also be looking to understand what Kenya's philosophy is around investment disputes in the sports environment. So we must begin to shape that. So there's a whole lot of things that need to be put in place. And so the bill and the policy just create a framework. That framework is really, because the bill is just foundational. What is it that we're putting on that foundation to ensure that the building blocks give life to the foundation that we have sought to put in place?
For someone who is interested in sports arbitration, first of all, as a means of dispute resolution for their transaction, how do they secure that in their contracts for someone who's not aware?
Well, first and foremost, you need to make yourself aware.
Yes, we're doing that now.
First and foremost, you need to make yourself aware. And secondly, I think you need to think carefully about your dispute resolution clause, and determine how you would like that dispute resolved. And you have to take into consideration various things: cost, time, enforceability, and just the pathway. One of the things that attracts me to our sports tribunal from a sporting perspective, it is friendly to our sports organizations and sports persons, because it mitigates the cost of it, because arbitration can be expensive. So you also need to be aware of your clientele. If it is a high value contract in which you want experienced arbitrators and so on, then maybe the tribunal may not be what you're looking for. However, the tribunal would still give you speed, and would still be able to give you enforceability, because of the multidisciplinary nature of the jurisdiction and the membership of it. So it is really horses for courses, as we always say. If you appoint me, or if you have a clause which says that each party will appoint the arbitrator, you need to be aware of what that will be costing you. But if you want to appoint the tribunal, because you can designate the tribunal, then also you need to be satisfied that actually one of the things you're doing is mitigating the likely costs. So if I was a lawyer advising my client, I would look at the nature of the transaction the client is getting into, whether it's a sports person entering into an image rights agreement with Kenya Breweries, or whether it is the Kenya Rugby Union signing a hosting agreement with World Rugby. That may not be suitable for the tribunal. It may well be that dispute, if it occurs, needs to be resolved somewhere else. If it is two federations entering into a cooperation agreement, maybe the tribunal will be the right place for them. So the point is to be aware of the existence of the tribunal, of its jurisdiction, of the benefits it offers, the speed of its ability to, let me just say, agility. Because I tried to make the tribunal as agile as possible. I'll juxtapose the Kenyan dispute resolution process for sports league, for instance, the Uganda one. The Kenyan one sets up a tribunal. The Uganda one sets up a dispute resolution process which requires the minister to appoint arbitrators. Now think about agility. If you are seeking injunctive relief, for instance, you then have to wait for the minister to appoint an arbitrator, the arbitrator to set out his terms of reference, his cost structure and so on, before he can give you interim relief, by which time the event may be overtaken by events.
Yes.
So I find the Kenyan model very responsive, and that's why I'm very attracted to it. Even in the UK, they don't have a similar model. A lot of the jurisdictions I've been to and spoken at about our Kenyan model, for instance, Malaysia is setting up a sports tribunal, but again, it is one that anticipates the appointment of arbitrators, independent arbitrators. So, speed, because now you come into the arena of emergency arbitrators and the ability to give you relief quickly, and then the nature of disputes that come before it. We must be alive to the nature of disputes that arise in the sporting environment and create structures that would be responsive to those sorts of disputes. So I would still retain our model, even in the bill, and that's what we've sought to do, to expand its jurisdiction, because I think, even if I say so myself, I think that it has been a good model, has served Kenya well and can serve Kenya well into the future.
Based on your comparison, even I see it. Sometimes you say that, as Kenyans, we're not there yet. But then when you compare,
absolutely,
right, then you see we might not be there yet, but we are somewhere. So that's a positive thing.
Yeah, certainly.
Now, as we really wrap up, Mr. Ohaga, you have served this Republic of Kenya in different capacities. Let me just put it that way. And I want to believe you have interacted with the lawyers, the administrators, the sportsmen, diverse stakeholders. For someone who, number one, may be a lawyer, perhaps even serving pro bono as the lawyers in the tribunal, or not a lawyer, a former athlete, in the other side of the technical elements. And I feel perhaps I would want to be a part of this service to the country or be appointed to such a task force. What does it take really? Is it being in the right rooms with the right people? Is it a mix of both? What do you think?
Yeah, it's a mix of all of those. I think that you must be very deliberate about building a reputation. But it's pointless building a reputation if you have no skill to display.
Merit must be there.
Merit must be there.
Yes.
So you must demonstrate merit.
Yes.
Yeah? And then try and get into the right rooms. Some aspects are chance. Chance, you have to say, must play a significant part. But I always think that fortune favors the prepared. So you must be prepared. When the opportunity arises, you must be able to put your hand up and say, here I am, I'm willing to serve. But the other thing that I think has served me well is never focusing on what is in it for me. I have, you could criticize the mindset, but my first thought has always been, how can I serve?
Service.
Yeah? My first thought has always been service. Forgive me, I went to Alliance.
It had to be said. Yes.
Our school motto was strong to serve. And it has stayed with me since I left that school. It has always been at the forefront of my mind. Strong to serve. How do I serve? And everything else follows.